Hello guys, welcome back to SQE2 Dispute Resolutions or Civil Litigation Interim Applications Part 3. In this video we will be talking about the hearing and without notice applications. Let's talk about the hearing first. Most of the interim applications are decided at hearing, as we already spoken in the first two videos. At the hearing, judge considers the application notice, draft order, the parties' evidence and the legal arguments made by each side. If you want to quickly recap, you can go back and look at my first two videos on dispute resolutions, interim application, civil litigation videos. So let's quickly go back. So at the hearing, the judge considers the application notice, draft order, parties, evidences, legal arguments made by each side, applicant and the respondent. Then the judge decides whether the order requested should be granted, refused or varied. So judge normally have three options. Either they can grant the application in favor of the applicant, or they can refuse the application, that means in favor of the opponent if they are opposing the application, or they can vary the order as well. Vary order means they can accept the order but conditionally. At hearing, a hearing does not require necessarily everyone to attend a courtroom in person. To further the overriding objectives under CPR 1.1, the court may direct that the hearing take place remotely, which means by telephone or video hearing. This may be appropriate where the application is relatively short or straightforward, and it can save the time and a cost as well. At the hearing, the applicant normally explains what the order is sought, why it is necessary, and what relatively evidence supports their application. And the respondent, if they're opposing the application, they also explain why the application should be refused and why the different terms should be imposed. For example, if they're looking for extension of time, the applicant give their evidences that they found disclosures which are, for example, thousands of pages, and the respondent can refuse, no, this is not the scenario, they already has been disclosed, that they have plenty of time. This is just one of the hypothetical example. The applicant may briefly reply to any new points raised by the respondent, and the judge will usually consider both parties' merits of the application and whether the applicant have behaved reasonably or not. For example, what the applicant is supposed to do, one, they need to act promptly. The sooner a matter has been risen, they need to act promptly. They cannot wait till the last moment. That means they have behaved. And the second approach they need to do, they need to reach to the other side and come up to an agreement so they can save the court's time as much as possible. If they cannot reach to agreement, or if the matter is that you definitely need the court permission, but you still need to approach to the other side to get them on a board. So, for example, the court may consider whether the applicant acted promptly, attempted to reach an agreement, and complied with the relevant procedural rules. That's one. And now let's go to the second one. When can the application be decided without hearing? Although a hearing is usual, the court may decide an interim application without holding one in certain circumstances. As I said, where the application is normally straightforward, they can do on the paper basis as well. One example is where the parties have agreed the terms of the order. In that situation, they may submit a proposed consent order to the court. The parties must provide a clear evidence that the relevant parties consent to the court order. The court will consider the proposed terms and may approve the order without requiring the parties to attend a hearing. Always remember, why do you need a consent order if you already both agreed, both parties? Because court also, your case is already before the court. So the court wants to see that even both parties are agreed, this is not abuse of process or this is not delaying tactics. So they want to be, because you already put the matter before the court, so the court wants to ensure that. And plus all the records in the court will be updated as well. However, the agreement between parties does not automatically bind court. That's exactly what I said just a minute ago. The judge still has responsibility for the case management and may refuse or amend the proposed order if its terms are inappropriate or too vague. So, which I said, even both parties agreed, that does not bind the court. Court can still accept, refuse or vary the order. Let's quickly go a real life example. The defendant requires an additional 7 days to serve a witness statement. The claimant agrees and both parties consider that the hearing would be unnecessary. They submit a consent order setting out the revised deadlines. the judge approves and seals the order without holding a hearing. So here, for example, on the contrary, if the judge thinks no, this is not necessary and they already taken too much time, so they can refuse the order, or they can amend the order. No, I'm not giving you 7 days, I'm giving you 3 days instead. So that's up to the judge, and they have powers to do so under the overriding objectives. Let's go to quickly next one, the court's decision and final order. After considering the evidence and arguments, the court will make its decision. The court may grant the order exactly as requested by the applicant, grant the order on different terms, refuse the application, adjourn the application for further evidences, and make additional case management directions. So court could do any one of these files. I'll go through again. So after considering the evidences and arguments, the court will make its decision. The court may do one of 5 or more. Number 1, grant the order exactly. So whatever applicant is seeking for, they can grant it as such. Remember, you'll be giving the draft order along with your N244 application. So they can judge can accept the application as you requested. They can grant the order on a different terms. They can vary the order. For example, if you ask for 7 days extension, they can give you 3. They can refuse the application, adjourn the application if the evidence is insufficient. So judge can vary the order as well. Adjourn the order for further evidences, make additional case management directions. Judge will also normally decide who should pay the cost of the application. As I said, the general rule is the applicant of the interim application. Whoever is making the application of interim application, normally the general rule is they will be paying for the cost, whether they are claimant or defendant. But in that interim application, whoever is making it, they becomes applicant and the other party becomes a respondent. The general rule is the person who is making application or the party who is making application will be paying the cost of that application. However, court have wider discretions. If the other party behaves unreasonably, the court can do the order vice versa. The party must carefully read the final order because it may contain new deadlines or conditions. Failure to comply with the order may result in sanctions. Hope you guys get that. Let's go to the next one, on notice and without notice application. Not every application requires notice. There are some applications can be done without notice as well. So let's go through the on notice applications first. The normal procedure is for the interim application to be made on notice, sometimes called with notice, because it is fair. If you make an application, the other party should have an opportunity to review, respond, oppose the application. So they should have an opportunity, which is very fair. This means that the respondent receives the application notice, supporting evidences, draft order before the court considers the application. The respondent therefore have an opportunity to understand what the order is being sought, file the evidence in opposition, attend the hearing, and make a legal submission. This procedure reflects the basic principle of fairness, that a person should normally be heard before an order affecting them is made. Under the CPR 23.4, a copy of the application notice must normally be served on every respondent, unless the rule, practice, direction, or court order permits otherwise. So this is very fair, simple, straightforward. Every application is a basic principle of fairness, equity, that every party in the application should be served the notice, so they have an opportunity to respond on that. Now there are some applications which can be made without notice, and we'll go through that, and then I will explain a little bit in my own wording. So a without notice application is made without first serving the application notice on the respondent. So obviously you will be making an application to the court, but you don't want to serve on the other party, and the reason behind that I will go through in a minute. The respondent therefore does not know about the application at all. It may sound a bit unfair, but we're going to come on the reasoning on that. Before the court initially considers it and is not present to oppose it. So respondent doesn't know anything about that. Application made by the applicant in the court considers the application, they decide the application, and then afterwards the respondent is gonna know. The older expression ex parte application may sometimes be encountered, but the modern CPR terminology is without notice. So that used to call ex parte application, but the modern CPR terminology is without notice now, because the respondent is temporarily denied the opportunity to be heard, to see the evidence, or see the application. A without notice application is an exception to the normal procedures. It should be used where there is a proper legal and practical justification. So it is very narrow, um, very narrow window that you can make this. When and why an application be made without notice? Number one, exceptional urgency. A without notice application may be justified where the remedy is needed immediately and giving the notice would cause unacceptable delay or defeat the purpose of the application. So say for example, there is an employer and employee. Employer making a claim against the employee is holding some very sensitive data and who is going to publish it online. If you give an application for injunction that courts makes an order to stop the employee, former employee, publishing that data, that means they probably already do it, then there will be irreversible harm. So therefore they don't want to give the opportunity to the former employee. They make the injunction. Obviously the court gonna go through all the fairness and equity, whether it is only the remedy can be given. Otherwise, if they give the notice, that would cause irreversible harm. So let's quickly go through a quick real life example. A claimant discovers that the defendant intends to transfer disputed money overseas the following morning. Giving several days notice may allow the defendant to remove the money or disperse the money before the court can intervene. The claimant may therefore seek an urgent freezing injunction without notice. For an interim remedy, under CPR 25.3 allows the court to grant relief without notice where there are good reasons for not giving notice. The supporting evidence must explain why the notice was not given. So imagine the same scenario which we given in the real life example, that if you give a notice to the other party and by the time court gonna intervene it's gonna be several days, that means the money is already dispersed. How are you going to bring the money back if the money being transferred into another jurisdiction where the court does not have powers to bring the money back? That means it defeats the whole purpose of the application. So in very narrow circumstances under CPR 25.3, court allows that. It's not, now there's another option. Overriding objectives is best furthered by the proceedings without notice. In some situations, dealing with applications immediately and without notice may be the fairest and most efficient course. This does not mean that the court may ignore fairness. The court must balance the need for the urgent and efficient actions against the respondent's right to be heard. I'll go through that again. Overriding objectives is the best furthered by the proceedings without notice. In some very narrow situations, dealing with applications immediately and without notice may be the fairest and most efficient way. Just think of the example I've given above. This does not mean that the court may ignore the fairness. That means the money is frozen till the final decision being made by the court. That does not mean the money is gone. That means the court want to preserve the money. So in case if the money belongs to the claimant, that does not be dispersed where they cannot bring it back. This does not mean that the court may ignore the fairness. The court must balance the need for urgent or efficient actions against the respondent's right to be heard. Number 3, all parties consent. An application may technically proceed without usual formal service requirements where all relevant parties have agreed to the course. In practice, clear evidence of their agreement should be placed before the court. Again, it's a consent agreement. That's technically not without notice, but if every party is agreed, that's not without notice. That means you have a consent agreement and you put that consent agreement before the court and you don't really give to notice it because notice is already given in the consent order. They're already aware of that. Number 4, the court gives permission. Applicant may ask the court to dispense with the service or permit the application to proceed without notice. So the applicant may ask the court to dispense with the service or permit the application to proceed without notice. Applicant must give proper explanation for requesting this exceptional procedure. I will say that again, these are very, very narrow windows. So the court does not give unless exceptional circumstances or extenuating circumstances apply. Number 5, a rule, practice, direction or existing court order permits that. So there is already a precedent or there is a rule or practice direction. Certain applications are expressly permitted to be made without notice under the specific CPR rule, practice direction or earliest court order precedent. For this exam purposes, always check whether the particular application has its own procedural rules rather than relying on a general provisions under Part 23. So always check whether the particular application you are making has their own procedural rules rather than before you go to the practice direction Part 23. Number 6, an application is made at an existing hearing. If it's already been made on the previous hearing, then you don't really have to give notice because every party already have the notices. A hearing may already have been fixed, but during that hearing a party may need the court to make an additional order. If there was insufficient time to issue and serve formal application notice, the party may ask the court or judge to deal with the matter at that hearing. However, the judge will consider whether the other party had a fair opportunity to respond. The court may refuse to deal with the issues immediately or may adjourn it before the respondent would unfairly prejudiced. Let's quickly go through a real life example so you can easily digest this part. So at a case management hearing, the claimant asks for permission to rely on a newly identified expert report. Remember, experts are there to assist the judge. You cannot rely on their evidence unless you have permission by the court. For example, if you have a case before the court which is on the medical negligence basis, so neither the judge nor the solicitors or barristers are doctors, so you need medical expert who can assist you on that. However, if you want to rely on their evidences, you need court's permission. So at a case management hearing, the claimant asked for permission to rely on a newly identified expert. There was not enough time to issue and serve separate applications before the hearing. So for example, the CMC is literally around the corner and you don't want to issue the proceedings because that's not going to be enough time to file at the court and then serve on the respondents. So you can ask the judge and the judge may deal the request immediately if the defendant can respond fairly. However, if not, the judge may require formal application and adjourn the issue. So this is under the discretion of a judge if the thing is not under the fairness rule. Procedural safeguards for without notice application, very important. Because the respondent is absent, the applicant owes a particular important duties to the court. So this is very, very crucial for the applicant now because they're asking not to give opportunity to the other side. The safeguard reduces the risk that the court will make an unfair order after hearing only one side story. So if this goes wrong, this is not a one-way road, guys. If this goes wrong, this is gonna come back to you and it's gonna bite you. So because the respondent is absent and you're asking not to inform the respondent, the applicant owes a particular important duties to the court. These safeguards reduces the risk that the court will make an unfair order after hearing only one side story. Applicant must explain why the notice was not given or should be given. The application and supporting evidences must clearly state why the matter is being brought without notice. It is not enough merely to describe the application is urgent. That's not only good enough. There has to be further evidences and circumstances. The application therefore should explain what the urgency is, why the notice could not reasonably be given, what harm might occur if the notice were given, for example, irreversible harm or too much damage which defeats the whole purpose, and why the matter cannot wait for an unnoticed hearing. A court may refuse the application if there is no satisfactory justification for excluding the respondent. Remember, you always need evidences. Okay, so duty of full and frank disclosure. A party making without notice application must prove full and frank disclosure. This means the application must not present only on the facts and legal arguments that favors its own position. The application must also draw the court's attention to the relevant facts that weaken the application, possible defenses available to the respondent, because now you are technically acting for both. You don't need to just tell that, okay, this is the application, these are the evidences, these are the facts, and these are the legal grounds from my side, because you asking the court that don't give notice to the other side, so that means you have to advocate for them as well. So the relevant facts that weaken the application, possible defenses available to the respondent, legal authorities that may favor the respondent, not you only, disputes about evidences, and any other matters that absent respondent would probably have raised. So now you have to do the advocacy on both sides. So you only don't have to give the facts and legal grounds from your side, you also have to give to the other side what if the defendant was here, that could have weakened these application under these facts or legal grounds or these evidences, this could go into their favor, and any other matter that absent respondent would probably have raised. The applicant must therefore act fairly towards the court despite seeking an order against the absent party. Let's quickly go through a quick real life example. A business applies without notice hearing to stop a former employee from contacting its clients. The business must disclose that the employment contract contains a restriction lasting only for 6 months and that 5 months already been passed. It must not hide that the fact simply because it weakens the application. So that's one of the points they also need to raise, that it's only 1 month left because they have 6 months restriction clause in the employment contract. Failure to provide full and frank disclosure can result in order being discharged and the applicant being ordered to pay for the cost, which they normally have to pay it anyway. Service after the hearing. After a without notice hearing, the applicant must normally serve the respondent as soon as practicable with the relevant documentations, whether or not the application was successful or not. So once the service after the hearing is done, whether in your favor or not in your favor, you must serve all the documentation including the decision on the respondent as soon as practicable. These will normally include the application notice, supporting evidences, the sealed court order, whether in your favor or not, any documents considered by the judge, and information about any further or return hearing. This allows the respondent to understand what happened in their absence and seek to vary or set aside this order where appropriate, because now the respondent gonna have the opportunity whether the order was successful or not, so they can respond on that. So they need to have the application notice, supporting evidences, sealed court order, documents considered by the judge, and any information about any further or return hearing. Let's quickly go to return hearing now, where the court grants an important order without notice. So where the court grants an important order without notice, it will often list for a further hearing known as a return hearing, because injunctions are without notice. Injunctions are always temporarily to stop a potential irreversible harm, so they always come with the return hearing. For example, in a family law, if a wife or a husband apply for restraining order or non-molestation order, they normally get it, and non-molestation order normally comes without hearing, without notice to the other party. So they normally court grants for the safety of the children or the wife or husband, whoever applies for it, but that always comes with the return hearing. On the return hearing, they normally get the chance that they can speak why this injunction should be stopped or why this shouldn't be on the first page, etc., etc. So when a court grants an important order without notice, it will often list a further hearing known as a return hearing. At the return hearing, the respondent can challenge the order. As I said, present evidences against the why order should not even be made, ask for the order to be discharged or varied, and seek an appropriate cost order. The initial without notice order is therefore often temporary. The return hearing restores the respondent's opportunity to be heard. Let's quickly go through a real life example. I always get it through the real life example. So a claimant obtaining a freezing injunction without notice because the funds are about to be transferred overseas. The court grants a temporary order and lists a return hearing 7 days later. The claimant immediately serves the order and evidences on the defendant. At the return hearing, the defendant may challenge the injunction and present his own evidences. Okay, we just got 2 more paragraphs to go, and then we're going to end this video. Sorry, this video is a bit longer. Consequences of misusing without notice procedures. A without notice order may be set aside if the applicant failed to disclose important information. As I said, this is not a one-way road, guys. So consequences of misusing the without notice procedures. A without notice order may be set aside if the applicant, number one, failed to disclose important information, because it's going to come back and bite you anyway. When it comes to the return hearing, and then if the court finds out there were important information which was under the control of applicant and they did not disclose it, then it's going to bite you back. So failed to disclose important information, exaggerated urgency, failed to explain why the notice was not given, misled the court, failed to serve the respondent promptly, breached the term of the order. So the applicant may also face an adverse court order. For the reason, solicitors should not use a without notice applications merely because it is convenient or because they want to prevent the respondent from opposing it. So no abuse of power or no abuse of system. Okay, so the applicant may also face an adverse court order. For that reason, solicitors should not be using without notice application merely because it is convenient for them or because they want to prevent the respondent from opposing it. So summary of the interim application. Let's just quickly rephrase all of that. We're going to glance through all of that what we said earlier. The normal sequence shown in the above said whole slide is: number one, issues, service, further evidences, cost management, and then hearing. At the issue stage, the applicant files an N244 notice, supporting evidences, a draft order, and the appropriate fee. After the issue, application, notice, supporting evidences, draft order, and notice of hearing are served on the respondent. The general rule is that the application notice must be served as soon as practicable after the filing and at least 3 clear days before the hearing. And let me just quickly go through 3 clear days. 3 clear days, you normally start counting backwards. That means the hearing day, that's we call event day, does not count. So say for example, the hearing is on Monday, and when it's 5 or less days, that you do not count weekends, bank holidays, New Year's Day, etc., etc. So if the hearing is on Monday, Monday does not count. Counting backwards 3 clear days is Sunday and Saturday. That will not be counted as well. If it's a more than 5 days, then you will gonna count these Saturday and Sundays as well. But if it's a less than 5 days, then it's a 5-day rule. So Friday is gonna be day 1, Thursday is gonna be day 2, and Wednesday is gonna be 3. That's the 3 clear days. Okay. Sorry, I just lost the plot where I was. After issue the application notice, supporting evidences, draft order, and notice of hearing are served on the respondent. The general rule is that the application notice must be served as soon as practicable after filing and at least 3 days before the court deals with the application, unless this rule says otherwise. Practical direction or court order provides different directions. For example, the respondent may then file and serve the evidences in opposition as soon as possible. The applicant may file limited reply evidence where necessary. Both parties should file and exchange their statements of cost at least 24 hours before the hearing. The judge then considers the documents, arguments at the hearing unless the application is properly dealt with without a hearing. So, practical approach for this exam. When advising on the interim applications, consider the following question in this order. First, does the respondent need a notice to be given? Not just is convenient for you, not just because you want the other party not to oppose the application. This is not good enough. So first, does the respondent need to be given notice? Second, if no notice is proposed, what legal basis and factual justification permit that approach? 3, has the applicant disclosed all the relevant matters, including points that favors to the respondent, means against you? 4th, what documents must be served immediately after the hearing? That's going to be everything: application notice, judge order, any things which judge indicated in the order, and all the relevant evidences which you have given it, including the direction. And finally, a return hearing required so the respondent can challenge the order. So this is all for the time being. Normally our video is about 20 to 25 minutes. This has gone to half an hour. I'll see you in the next topic. Thank you.